Ladies, let me ask you something serious. If something were to happen tomorrow, would your will protect your loved ones exactly the way you want, or would it leave behind confusion, disputes, and unnecessary costs? Most women assume their will is fine. But as a lawyer, I can tell you there are 7 common mistakes I see older women make all the time. And these mistakes can completely undo your intentions, hurt your family, and even hand over control to the courts. So, watch this all the way through, because avoiding these mistakes is the difference between leaving behind peace or leaving behind a mess. And before we dive in, make sure to like this video, subscribe, and comment below with peace of mind if you want your legacy to be handled properly. Mistake number 1: thinking a simple will is enough. One of the biggest traps I see women fall into is the belief that a simple one-page will is all they'll ever need. Maybe you've picked up a will kit at the local office supply store, or you downloaded a template online and thought, well, this covers the basics. I'll just fill in the blanks. The danger with this approach is that life and the law is rarely that simple. A generic document often leaves out critical details that make the difference between a smooth inheritance process and a painful drawn-out legal battle. For example, what if one of your heirs passes away before you? Does your will say what happens to their share? What if one of your assets, like a property or investment, no longer exists by the time you pass? Does your will explain how to redistribute things fairly? I once advised a family where the mother had used a will template she found online. She thought it was straightforward. I leave the house to my 2 children. The problem was she didn't specify how they should divide the house. Should they sell it and split the proceeds? Should one child be able to buy the other out? Should they both live there? The siblings ended up in court for 2 years fighting about what their mother would have wanted. The estate ended up paying thousands of dollars in legal fees that could have gone to the children. A simple will might feel like it covers the basics, but life is rarely basic. Without clarity, detail, and proper legal language, your wishes can be ignored or worse, misunderstood. Mistake number 2: forgetting to update the will after major life changes. This mistake is shockingly common. Many senior women write their will once, tuck it away in a drawer, and never look at it again. But your will should grow and change with your life. Think about it. How many changes have happened in the last 10 or 20 years? Marriages, divorces, new grandchildren, loved ones passing away, or even financial shifts like selling a house or receiving an inheritance. If your will doesn't reflect your current reality, it can lead to devastating consequences. Let me share a real-life story I encountered. A woman in her 70s had a will that still listed her ex-husband as the primary beneficiary. She had remarried but never updated the document. When she passed away, her current husband was left fighting in court, while the ex-husband, who she hadn't spoken to in decades, was legally entitled to much of her estate. It's heartbreaking and yet completely preventable. Even smaller details matter. Say you leave money to my grandchildren. Do you mean the grandchildren you had when you wrote the will? Or do you mean all grandchildren, including the ones born later? If your wording isn't updated, the courts may only include the ones who were alive when you signed the document. Imagine the hurt feelings that can cause. A will should never be a one-and-done. It's a living reflection of your life circumstances. My rule of thumb: review your will every 3 to 5 years or immediately after a major event like a birth, a marriage, a divorce, or a death in the family. That way, your wishes remain current, accurate, and legally protected. Mistake number 3: not naming a backup executive. Choosing an executive, the person who carries out your wishes, is one of the most important decisions you'll ever make in your will. Most women pick someone they trust, like a spouse, an adult child, or a close friend. But here's the mistake: they forget to name a backup. Executives are human. Life happens. The person you name may pass away before you become too ill to handle the responsibility, or even refuse the role when the time comes. If you haven't named an alternate, the court may step in and appoint someone you never intended. That could mean a distant relative or even a professional stranger who charges fees that drain your estate. I've seen this play out in heartbreaking ways. A client once named her oldest son as executive, trusting him completely. Sadly, he passed away suddenly before his mother. Because she hadn't named a backup, The courts appointed a more distant family member who had very different ideas about how things should be handled. It created years of tension among the surviving siblings who believe their brother would have done things differently. An executive's role is not just about signing papers. It's about making sure your values, your priorities, and your love for your family are honored. By naming a backup executive, you provide a safety net. It's a small, simple step, but it prevents enormous stress later on. Think of it as a seat belt for your will. You hope it's never needed, but if it is, it can save your legacy from being derailed. Mistake number 4. Leaving unequal gifts without explanation. This is one of the most emotionally charged mistakes, and it often leaves scars that never heal. Many senior women decide to divide their estate unequally among children or grandchildren. Sometimes it's because one child received financial help earlier in life. Sometimes it's because one child became the caregiver, and sometimes it's simply because the parent believes one needs more support than the others. The problem isn't the decision. It's the lack of explanation. If you leave unequal gifts without addressing why the people left behind may assume favoritism, resentment, or betrayal, siblings can stop speaking to each other. Families can split apart. And what should have been a final act of love becomes the beginning of a feud. I once worked with a family where a mother left the majority of her estate to her daughter, giving her son only a small fraction. The daughter had been the one caring for her during her final years, but the will never explained that. After the mother passed, the son felt downed and humiliated. He fought the will in court, and the case dragged on for nearly 4 years. Both siblings lost money in legal fees, and worse, they lost each other. This could have been prevented with a few simple sentences in the will, or even a heartfelt letter kept alongside it. A clear explanation doesn't erase disappointment, but it prevents misunderstandings. It tells your family, this wasn't favoritism. This was fairness in my eyes based on circumstances you may not fully know. If you choose to divide things unequally, don't leave your loved ones guessing. Tell them your reasons either in writing or in person, because your will isn't just about assets. It's about the legacy of your relationships. Mistake number 5, forgetting about digital assets. This is one of the newest and fastest growing problems I see with wills. In the past, an estate was mainly physical things, homes, jewelry, bank accounts, investments. But now, so much of our lives is digital. And many senior women don't even realize how big this issue is until it's too late. Think about all the digital assets you might have. Email accounts, social media pages, online banking, digital wallets, loyalty points, cloud storage full of family photos, maybe even cryptocurrency or PayPal balances. These things can hold sentimental or financial value. And yet, most will completely ignore them. Let me give you an example. A client of mine passed away with hundreds of priceless family photos stored in a cloud account. Her children wanted to access them, but they had no passwords, no instructions, and no legal right of access. The company wouldn't release the photos without a court order. Those images, decades of family history, sat locked away. And by the time the legal battle ended, some of them were lost. The family was devastated on the financial side. I've also seen situations where online investments like cryptocurrency accounts or PayPal balances went unclaimed simply because no one knew they existed. Companies don't always go out of their way to find heirs. If no one claims the funds, they can eventually be absorbed by the institution or government. Addressing digital assets in your will is no longer optional. It's essential. You should list your important digital accounts. Leave clear instructions for access. Decide who inherits them or manages them. It might feel uncomfortable to write down your passwords, but there are secure ways to store this information, such as through a digital vault or by giving access to your executive in a safe manner. Ignoring this step could mean your digital life disappears, and along with it, memories and money that belong to your family. Mistake number 6. Naming the wrong guardian for grandchildren. This one is perhaps the heaviest mistake because it directly impacts the lives of children. Many women want to ensure that if something happens to the parents, their grandchildren will be safe, loved, and cared for. That's a beautiful instinct. But what often goes wrong is naming a guardian without carefully considering the long-term consequences. Here's what I mean. Love is not enough. Just because someone loves your grandchildren doesn't mean they're the best person to raise them. The guardian you choose should be financially stable, emotionally capable, aligned with your values, and able to handle the responsibility for years to come. I once encountered a heartbreaking case where a grandmother had named her sister as guardian for her grandchildren. On paper it seemed like a good choice. She was loving, close to the family, and had always been supportive. But the sister was in her late 70s with health issues of her own. When tragedy struck and guardianship became necessary, she simply couldn't keep up with the demands of raising young children. The courts eventually reassigned custody, but the transition was traumatic for the kids. There's also the issue of distance. Maybe you adore a family member who lives across the country, but uprooting children from their schools, friends, and routines can be incredibly disruptive. Or maybe you're considering someone who is wonderful, but doesn't share your values. Religious, cultural, or even lifestyle differences can have lasting effects on how children are raised. When naming a guardian, ask yourself tough questions. Can they realistically handle this responsibility for years? Do they have the financial means, or will they be overwhelmed? Do their values align with what you want for your grandchildren's upbringing? Are they geographically close enough to provide stability? It's not an easy choice, but it is one of the most important. And remember, you can also leave financial provisions to help support the guardian. That way, the person you choose doesn't have to bear the cost alone. Choosing the wrong guardian doesn't just cause legal headaches. It can shape a child's entire future. That's why this is a decision you should revisit carefully and update if circumstances change. Mistake number 7, not seeking proper legal advice. And finally, we come to the single biggest mistake. Trying to do it all yourself without proper legal guidance. I know why so many women make this choice. It feels expensive, intimidating, or unnecessary. After all, there are kits, websites, and even apps that promise a fast and easy will. Why hire a lawyer? The reality is this. Estate laws are complex. They vary not only from country to country but often from state to state. A will that looks perfectly fine in one place may be completely invalid in another. And the smallest error, a missing witness signature, unclear wording, or even using the wrong type of paper in some jurisdictions can throw your will into chaos. I've seen entire estates tied up in court for years because the deceased used a do-it-yourself. Well, that didn't meet the legal requirements. I've seen families torn apart because of vague language that a professional would never have allowed. And I've seen people lose huge amounts of money in unnecessary taxes and fees because the will didn't take advantage of legal tools that could have saved them. Let me give you one story. A woman created her own will using a template she found online. She thought she had done everything right, but she lived in a state that required 2 witnesses for a will to be valid, and she had only one. When she passed away, the court declared the will invalid. The estate was distributed according to default state law, not her wishes. That meant erunged relatives inherited large portions, while the people she actually wanted to benefit received nothing. Legal advice isn't just about paperwork. It's about peace of mind. A lawyer doesn't just draft documents. They ask the questions you may never think of. They help you account for every possibility, ensure your wishes are airtight, and protect your family from unnecessary conflict. Yes, it costs more upfront, but compare that cost to the tens of thousands of dollars your family could lose in court battles, delays, and disputes if your will isn't legally sound. The truth is, seeking professional advice is one of the most loving gifts you can give to your family. It saves them from confusion, arguments, and heartbreak when they should be focusing on remembering.